Now, today's show, we're speaking about if you're a buyer and you're going to buy a piece of property and it's tenant occupied.
Yeah.
Boy, there's a lot of issues there. So.
Yeah, there's a lot of issues, but you don't have to be too wary as a buyer. There's ways to go about buying a property with a tenant that you can protect yourself, and that begins with research. Usually, either before you make the offer or after you make the offer, you'll get a disclosure package from the seller or seller's agent, and you should really go through those in detail and look at what kind of lease the tenant has, look to see if there's any rent control ordinances and those types of things.
Okay, now for the audience members, a disclosure package is typically Silicon Valley, right? And that is, not everyone uses it, not all agents use it, but typically that is electronic folder full of documents. It might be a roof inspection, chimney inspection, and so on and so forth. Now, since agents don't always use a disclosure package, now it's really up to the buyer to find these things out.
Right.
That's right. Well, and the buyer's going to get a certain amount of information regardless of where they are. There's a few of the documents that are included in that disclosure package that are universal. And so documents such as the transfer disclosure statement, the seller property questionnaire, and what's often called a tenant estoppel certificate are regardless going to be provided, or should be provided, I should say, to the buyer at some point during the transaction.
Right.
It doesn't always happen. That's a story for another time. But the buyer's going to want to look at those documents very closely because they're going to be critical to making that buying decision.
Okay, that's a great point about this estoppel. And I remember years ago a real estate attorney at a seminar described the key word there was stop, meaning a tenant in their own pen writes, this is what my rent is per month, this is what I understand my term is, and this is my cleaning deposit and security deposit. And they sign it, and they are stopped from coming back later and say, oh, no, that wasn't correct.
Right.
That's correct. Yeah, the tenant's held to that information they put in that form.
Now, oftentimes we don't have those forms available, so the tenant or the buyer should be asking for that.
Yeah, Adam can talk about how buyer's agent can put that in the contract to actually make it a requirement in the sale.
Right, there's a simple mechanism to do that, right?
That's correct. When the buyer is making their offer, typically they would use a form like the California Association of Realtors form for making that offer, and there's a box that can be checked, and it's simply ticking a box, and that indicates that the property is being purchased tenant-occupied, which requires the providing of that disclosure, those estoppel certificates, as a contingency to the contract. And what that means in layman's terms is that if those documents don't come through, or if they contain information that's not acceptable to the buyer can back out of the deal without consequence. So you can see how just checking that little box makes a big difference in the buyer's rights.
Okay. Now, in terms of the lease, oftentimes the tenant's been in there so long that one party might have a copy of the lease and the other party might not.
That's the benefit of the estoppel certificate, is you're getting from, they say, the horse's mouth what he believes or she believes the lease is. And cases have actually come down where courts hold the tenants to what they put in the estoppel certificate, so it's very powerful for the buyer.
And I know you have mentioned over time, Ashlee, that you've seen leases or rental agreements that look like a historical document.
Yeah, I feel like someone's going to pop out and roll out a parchment and is going to read the lease terms to me. They're that old. And it's not uncommon. People got into the market if there's a slowdown at some time or some kind of change. You know, they've had the property a long time, and now for whatever reason they're deciding to sell, and they haven't updated their lease, and so that's where you run into problems.
Those leases are so old. That's when the landlord hired an esquire, right?
Correct.
Okay. So, in terms of seeking legal advice, we say this all the time, and some people are prudent about it, some don't. I know I've had to talk people in to seek, call me up for advice, and I say, you have to sit down with an attorney. We have the same conversation month after month. I said, didn't you speak with an attorney? No, I didn't. I went online and I did this, that, and the other.
Oh boy.
Yeah,
that's a problem, because we've had cases come down recently into our office where the buyer flew in blind and didn't seek legal advice, and there's rent control ordinances in that jurisdiction, and while he thought he could just get the tenants out and move new ones in, wasn't the case. It was a jurisdiction in which he needed a just cause, and that isn't
Okay.
a new purchase or something similar to that.
Okay, there's a couple of good topics there, because oftentimes the buyer's agent's moving along, the buyer's agent wants to make a sale. No problem with that. However, now the buyer is looking for investment property, and together they're moving forward. They're not speaking for, oftentimes the buyer's not talking to an accountant, and the buyer's not talking to an attorney.
Right.
And they say, well, this is a perfect property, and the stars align, and they bought it on, say, Monday the 1st. And they're into the transaction.
Right.
And now they start finding out problems.
Right, yeah, and it brings to mind a specific case that we dealt with once, and you kind of had a perfect storm where the buyer's agent was unaware of rent control laws in that area where the purchase was being made.
Mm-hmm.
The seller and the listing agent did not disclose the existence of rent control in their disclosure materials, so the buyer reviewed those yet remained unaware.
Right.
And then as the transaction was approaching close of escrow, the buyer learned that they would not be able to raise the rents on the building like they thought they had been able to do because of this rent control law that was in place. So it completely messed up the metric for their purchase. The value that they had seen in the property was almost gone, and so you can imagine that it caused a huge fallout. But thankfully we were able to step in there and leverage a little bit of that situation, since there was a little bit of misstep on both sides, and get them to come to an agreement that was mutually acceptable.
Okay, this is a big deal, because on the multiple listing service, this has been around forever, where the licensees will type in a listing, and there are spots for the rent. The first unit, the rent, second, and so on. And some sellers' agents might fudge on those numbers. Right?
Right.
You had a good point. I had spoken to you before about where some listing agents representing the seller, together with the seller, they would issue rent increases.
Right. Right.
Solely for the purpose to be able to go on the
Sure.
multiple listings and list a higher rent.
Yeah, especially with investment properties, rent is quite often what drives the value of the property, because that's what investors are looking
It's
at.
everything.
Income stream.
Yep.
And so that was exactly what had happened. The listing agent came in and looked at the rents, felt them they were under market, and said, okay, let's step these rents up. This was all done in the weeks before the listing. So the property was marketed as having this rent potential, but that's really all it was at that point in time, was potential, because that rent had never actually been collected. And in this case, to turn back to the estoppels did not make it through to the buyer's side. Buyer's agent didn't realize that. Buyer didn't realize that. And so there was no information from the horse's mouth, as Ashlee said, to verify that these stepped up rents were actually real. And in fact, they were not.
Okay. Now let's move on to the agent that's representing a buyer.
Correct.
Okay. Now, the fiduciary duty, we hear about this term all the time. What does that actually mean?
It just means that you have to have your client's best interests in mind and do everything you can to advance those interests. And a lot of people think that, as agents that represent a buyer, you get your disclosures, you get your estoppel certificate, and it stops there. And we don't believe it does. We think that you should go the extra mile, go to the county, go to the city, go online, even recommend they go seek an attorney, and make sure that they understand what the disclosures mean and what the lease means. And that way they can make a decision whether to continue or not.
Okay, Adam, you have mentioned before about the ordinance.
Correct.
What is, now throughout the Bay Area, we have rents that have gotten out of control over the years, and the cities want to have the school teachers and firemen living in their communities.
Right.
And so a lot of the cities have gotten together and put in place rent control.
Right. So as the buyer's agent, you're going to want to, at a minimum, to meet your fiduciary duty, know which communities are affected by rent control, so that if you have a buyer that's looking in that area, that you can at least refer them to legal counsel to analyze what is the impact of that rent control ordinance on this transaction. What is it? Is it going to hurt the value of the property? Can I evict the tenant? Can I raise the rent? Those are all questions that need to be answered, ideally, before your client even makes an offer. So if you don't know that, I don't think, in my opinion, that it's sufficient to just ignore that issue. You've got to issue spot it and get them to the appropriate person to get the help that they need.
I agree. I think that it all starts at the beginning when you first meet your client, and you need to get to know your client. Ask some questions. What do you want the property for? What do you plan on doing in 5 years, 10 years, 20 years down the road? And that will solve a lot of problems and save you from liability, because if you don't know what your client's intentions are, you may not be able to meet them, and they may come back and point the finger at you when they're not able to do what they want to do. So for instance, if they want to move all the tenants out and get fresh ones in, or move in family, whatever the case may be. I've had a client that wanted to buy a property by a university and wanted his nephews and nieces to live there while they went to the university.
Oh.
But he wasn't able to move the tenants out, and so the buyer's agent was kind of on the hook there because he didn't ask questions. And that's, I'm sure you know, as an agent yourself, that is normal for some people in the industry due to technology. They don't really meet face to face, or whatever the case may be.
Right. And that's really important in that the due diligence for the buyer's agent.
Right.
And oftentimes agents want to be a source for information and a know-it-all. And this is sometimes where you have to think outside the box and speak to your sales manager, your broker, call the city, really do all sorts of due diligence.
Right.
And that's what you mentioned, Ashlee, about setting expectations with the buyer. This is a good idea. If that was their intention, they could have just gone 1 mile north, east, west, south into another city and been able to accomplish that task.
Right.
Yeah, and it ends up resulting in hundreds of thousands of dollars, either in attorney's fees, your insurance.
Right.
It's just a mess, really.
Yeah, and that's the basis of the show, or consumer protection with the real estate attorneys that I meet with and I see you speak. You had a great webinar a while back, and it was really, and of course, Ashlee, you've spoken about just about every problem you have ever come across was completely avoidable.
Right.
Totally. Right.
Okay. Now, what about in terms of the buyer's agent? Now, buyer's agent, in my opinion, many do not like to go to the property to meet a roof inspector.
Okay.
And then they have to come back on Tuesday and meet the termite inspector, and so on and so forth. So how do they handle that, Ashlee?
They handle that by coordinating with the seller's agent, building a good relationship, and especially with a tenant inside, if your client wants to buy that property, try to coordinate things on one day. We're all together, have an appraiser show up in the morning, inspector later on. And that saves you trips and also saves the tenant from being further invaded by all these random vendors.
Okay, so now there's, by full disclosure, I always joke that it's not location, it's communication, right? So this right here, the buyer and the buyer's agent is dealing with someone's home, even though it's a rental, right?
Right.
So the tenants have that right. Now, one of the ways for them to communicate is the buyer's agent out there listening or watching has to be aware of what form, what's a good form. Ask for a particular form. Is it in play? Can we give an oral communication for entry, or do we have to give a written?
So that's accomplished by typically either the seller or the seller's agent delivering a notice of sale and entry form, and that allows the property to be accessed on 24 hours oral notice. So if you're a buyer's agent, that's a very good form to know about, because you're exactly right. You're going to want to be asking, hey, have you served this form? What kind of leeway do we have in communicating with the buyer? And then again, be very diplomatic. Respect whatever rules or regulations or procedures that the seller has in place, because that tenant in 30 to 45 days is going to become your tenant. And all of a sudden you've got that relationship, and if you've sullied it during the escrow, then you're going to be spending a long time recovering from that.
Okay. Now that's a good point. So let's say if that form is in place, the buyer's agent and or seller's agent can leave a voicemail that we will be by tomorrow with the termite inspector at 12 noon.
Correct.
Now if that's not the case, they have to give written notice.
Yeah.
Now can that be just a note on the door?
It could be. I don't recommend buyer's agents doing that. However, when there is a tenant inside, I would let the seller's agent be the leader and coordinate that. A lot of times buyer's agents will call the tenant directly, leave a message, not hear back, and show up. And we've even seen it go as far as calling the police for trespass. It's a nightmare.
Oh, sure.
Yeah, and so I would try to put it on the seller's agent, and they should take that initiative to do that, since it is their client's tenant still, and facilitate that arrangement.
Yeah, I have literally defended lawsuits against buyers and their agents for exactly that,
Yeah.
where a tenant is in a rent-controlled jurisdiction specifically because the tenant wasn't subject to eviction, so the tenant, again, became the tenant of the buyer, but during escrow, the buyer had aggressively sought access to the property and
Right.
got sued for that after the close of escrow.
Right?
Yeah, I know you have spoken about that before. Just accidentally,
Yeah.
people can get nailed for
yeah.
harassment.
Right. Well, people don't understand that trespass as an offense, civil offense, is actually not an intentional tort in the sense that you don't have to be acting with what we call malice.
Yeah.
You could simply go onto the property. That's enough, as long as you went on purpose. I didn't push Pat onto the property. Pat stepped onto the property. That's the only level of intent required. So
Right.
it's
Wow,
actually
that's
not what
crazy.
people think.
Yeah, I know. I grew up camping, and you never walk across somebody's campsite, right?
No.
Yeah.
It's the same thing, right? Now, in terms of the negotiation of having, I don't like to use the word eviction,
Mhm.
but let's say it's everybody's best interest if the buyer leaves early.
Sure.
Right.
How do we accomplish that?
Well, there's some jurisdictions where rent control is not existent yet, or either never will be, and the buyer's agent can be creative. They have addendums and forms with the California Association of Realtors where they can write in conditions that the seller can accept, and those can be: buyer shall pay an extra $5,000 to $10,000 to facilitate an eviction. Help the seller pay for it. Do something out of the box that makes it easier for the transaction to go forward, and also get the tenant out. I always recommend that, just because it can save everyone headaches, and it looks like you're making showing a good faith.
Yeah, I know. I've spoken with a lot of sellers agents over the time, and or sellers, and they say, boy, they're afraid of the occupant. If the occupant's
Sure.
not, we have all types of people, right? And there's occupants that are not tenants that are not cooperative and difficult,
Mhm.
Yeah.
and there are ones that are just wonderful. Now, we'll get into that in a minute. If you're a tenant, how can we help that? But now, in the case where there's it's a multifamily property, for instance, let's say there's 16 units,
Mhm.
and some have it's a rent control situation. Now, does that Section 8 housing change? Does that still? Do they supersede rent control? If you have, in other words, it's layered, it seems to me. We have Section 8 housing, we have low-income housing, and then we just have rents at several $1,000s a month in the same building.
Right. I think the important thing for the buyer is really those areas with rent control. That's where you're going to have the biggest problem for a few different reasons. Number one, in those areas, there's usually only 8 to 10 reasons you can move the tenant out. And so if you have a plan to turn over those units, you need to ensure that you've got an enumerated reason in order to do that. Otherwise, you're
Okay.
not going to be able to.
That's a good point. So if you're buying a building with 8 to 10 apartments, and there's a spreadsheet with 8 to 10 reasons why you need,
Yeah.
Right.
right?
And
Okay.
also, a lot of rent control areas have what we call relocation assistance or relocation payments. And a lot of landlords or buyers don't know about this, but you simply cannot evict the tenant for any reason, even if it's one of those 8 to 10, without making a payment to that
Right.
tenant for relocation. And it can be substantial, as $10,000 to $12,000 per adult tenant in
Right.
the unit.
Wow.
So one time I had a case where there was an attempt by the seller to buy out the tenants in order to market the property, and they didn't pay enough, and that payment fell short of the relocation payment and was, in essence, in violation of the ordinance. Not with any intent, of course, but just simple lack of knowledge.
Okay, again, that's how consumers can get into trouble accidentally.
Correct.
Right?
Yep.
Right.
Okay. So I remember as a kid I walked across somebody's camping site and I heard about it. All right. So now let's speak about you're a tenant. Now the buyers and sellers have to be reasonable. You've always spoken about that.
Correct.
Correct.
Now they just can't say, hey, I'm in the area, do you mind if I stop by?
That's right. That's right. The tenant under the Civil Code, it's Civil Code Section 1954, but that controls access to the property, and it requires that the buyer and the seller be reasonable in their access. So, things like we've been talking about, consolidating visits, consolidating inspections, those are all things that are expected of the buyer and seller. But the tenant should also know that that reasonableness requirement is on them as well. They can't simply block access or, say offensive things to the potential buyers when they come over. They've got to act reasonably in their own conduct with respect to both the showings and to their exchanges, their communications with the potential buyers.
Okay, there's several things here that could boomerang back on a consumer accidentally, and the same thing goes for a tenant. If the tenant gets cute and is stopping, having a hindrance on the sale, they can get into trouble too. Is that right, Ashlee?
It's substantial. I think tenants get the mindset that they sort of play king of the hill, or this is my fortress, and they can do whatever they want since they have a lease. And I've had clients that have had tenants literally stand there and block the door and don't let anybody in.
Wow.
But you have to be mindful as a tenant that any decrease in value due to your actions, since as a seller you do have to disclose that, you could be on the hook for. So you're not invincible, and you do have to comply with the code, because not only can you be liable for damages, you also can get evicted, and that goes on your record. And finding a new place, especially in a competitive market, will be very difficult.
I know throughout my time as a licensee, I'm previewing property, and the tenant will show me everything that's wrong with the property.
Right.
Very politely.
Yeah.
So that could be a problem. So that you refer to that as interference as an Esquire?
Absolutely, yeah. I haven't had a case yet, but I certainly think that some sellers would have a case against their tenants for their actions, just because buyers back out, they get scared, and the finger should be pointing at the tenant. And a lot of people don't know that as a tenant and as a seller that they can't interfere. You have to comply with the code. It's super straightforward. The only unfortunate thing is that there aren't a lot of mechanisms for a seller to enforce entry. While there's a notice of sale of entry form and the civil code, it's difficult. And so we've talked about before keeping a good relationship with a tenant, and this is where it really comes in handy when you need them to provide access. While you can go get damages, it's just easier to have a good working relationship.
And it's really tricky because the occupants have key to their front door, and the sellers typically have a key to the front door, and the property manager might have a key to the front door. And now the occupant's saying, wait a second, the tenant's thinking, now the buyer's agent's going to get a key, or the seller's agent? So how do we work together to set, if you're a tenant and you're learning about this, what should the tenant say to the seller's agent, for instance, how we want to handle this?
Well, I think initially I would hope that the seller and the seller's agent have been actively planning for this sale, and so have had the foresight to sit down early with the tenant and start that conversation. And then as the tenant, that's your cue, that's your signal that, hey, this is an opportunity to work with the landlord on many levels for many reasons. One, the code obligates you to do it, and two, if there's a potential negotiation for a buyout, you want to preserve your leverage by not making mistakes or getting cute and sort of falling outside the code. Now the landlord has leverage against you, so you want to preserve your position, work with them, and schedule with them, open houses and all that stuff. Keep it straightforward.
That's a good point. In closing out here, I know the best way to do it for the real estate community is have set times up front.
Oh, yeah.
And that this is when you can expect traffic. 24 hours notice. Ashlee, you're always speaking about, let's have the listing agent, the seller's agent involved.
Yeah, I would prefer that.
Okay. All right. Hey, thanks again for coming out.
Of course.
Thank you.
Thanks for having us.
Thanks again for watching Kapowich on Real Estate. This is a program dedicated to consumer protection within the residential real estate arena. We will see you next week. Same time, same channel. Thanks again for watching. If you're listening at home, there's more shows to be coming down the pipe. Thanks again.